Please be aware that the court does not allow any eating, drinking, or use of personal electronic devices during argument. Also, we're asking everyone to stay seated during the argument. At the break, you're welcome to leave, but please do not get up in the middle of argument. And the court will be in shortly.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session. All persons having business before the court are admonished to draw near and give their attention, for the court is now sitting. God save Texas and this honorable court.
Please be seated. Good morning, council. Thank you for being here with us today. I will now call our first case on the docket this morning, PD 0006-25. As you approach the microphone today, if you could do us the favor of reminding us of your name and who you represent, it will help us keep track of these arguments afterwards. We'll hear first from counsel for the state of Texas.
May it please the court, my name's Clay Nelson. Nathan Maury and I represent Bear County in the state of Texas in this case. The Court of Appeals opinion is wrong for 3 chief reasons. One of them is that their decision is at odds with the plain text of the Sixth Amendment of the Constitution, which states that in all criminal prosecutions, the accused shall enjoy the right to assistance of counsel for his defense. And 10 years after a no bill and a dismissal, Ms. McDonald was not an accused under the Sixth Amendment.
Was there still a complaint that was pending, or had the original, a lot of times police officers will file a complaint. Was there a formal dismissal of that complaint?
There was not. So there was a finding that the charges were dismissed in, I believe it was May of 2008. And what the testimony showed, specifically from Joseph Appelt and Ms. McDonald's counsel, is that she was told by the state that the state did not have enough evidence to prosecute her at that time.
Counsel, can I
Yes, Your
kind
Honor.
of back you up a second? Could you sort of fill in some of the empty spaces here? What crime is this? What are we dealing with as far as the facts of this case are concerned?
So the offense itself arises out of a car crash in 2007, which involved the death of an individual, Brandon Fletcher. At that time, Ms. McDonald was investigated, and she was at that time arrested and charged with, I believe there it was failure to stop and render aid and manslaughter. In 2008, that case was taken before a grand jury and no bill. And then 10 years later, Lieutenant
And
Sullivan.
before, just to make sure I am correct on this, before it was no bill, though, she was advised of her right to have counsel. She was appointed or retained counsel, so she had counsel before the case was no bill.
Exactly.
Okay.
So Joseph Appelt was retained as counsel. That's
Okay.
correct.
Right.
So the cases were taken before a grand jury in 2008, and they were no bill. So 10 years later, the same detective,
Counsel,
Yes, Your Honor.
didn't the case get no bill twice?
it did get no bill twice, according to Joseph Appelt. That's right. So 10 years later, Lieutenant Sullivan, who is the same detective who originally investigated the case and handled the case, reapproached Miss McDonald at her home. So this, fast forward, is now 2018. So he approaches her home, asks to speak with her, and then proceeds to engage in the conversation, which is depicted in, I believe it's Detective Goodwin's body-worn camera, where she references Joseph Appelt, makes a number of statements. After that,
The statement, and then the statements are something to the effect that she has a lawyer, and her lawyer said not to talk to the police.
something to that effect.
Well, she effectively seems to understand Miranda warnings at that point. Is that fair? Though they're not given again.
Correct. So they're not given, and what I would suggest is she does understand that. I believe at one point in the body-worn camera, she walks away, she goes upstairs, and then she says something to the effect of, "I don't have to talk to you, not without my lawyer." She then decides to come back down, and then she actually tells Detective Goodwin specifically, "You can come back and talk to me. Lieutenant Sullivan, you stay away." And so,
I'm just curious, procedurally, once she was arrested, she had to make an appearance in court in Bear County, correct?
correct.
And that was on the court's docket. Although she was no billed, was there a formal dismissal that the state signed in relation to the charges?
I believe there was. Although actually, I don't know that it's in the record exactly what the dismissal was. For example, in Fry, I believe there was a specific notation that it was for further investigation. I don't believe that the actual dismissal itself was tendered. Beyond the testimony that the prosecutors told Joseph Appelt, they didn't believe they had enough evidence at the time. I don't think there was a specific reason in the record, or rather the dismissal I don't think was specifically in the record.
It's undisputed that her Sixth Amendment right did attach back then, right?
Absolutely. So the question that we have today is, at what point, here specifically, at what point did she cease to be an accused, which would give her protection under the Sixth Amendment with her right to counsel?
Well,
Or
if she
if.
Or if.
Or what?
If.
Well, typically it's because she's been, jeopardy's attached, or she's been acquitted, or the statute of limitations has passed, right? None of those kind of legal things happened, did they?
That's correct. There was no statute of limitations. She was investigated for and charged with the exact same offenses, at least for the purposes of Blockburger. I think she was charged with intoxication manslaughter the second time around. Although I could be getting those backwards now that I think about it. In any event, for Blockburger purposes, it didn't matter. There was no statute of limitations, and we're talking about the two exact same for purposes of Blockburger
So
charges.
she had a Sixth Amendment right that attached, which is the language that's used with respect to that. And then it never was severed or detached in any legal way. What you're suggesting is that it just kind of dissolved.
So I think that our specific contention is that when charges are dismissed, someone is no longer an accused under the Sixth Amendment. There's no longer a criminal prosecution that is still ongoing. What I think Fry and other cases suggest is that there is an exception where there was an intent to actually circumvent her Sixth Amendment right by the dismissal, essentially to manipulate the charging timeline.
Does there have to be some sort of a dismissal, like a formal dismissal, as opposed to just, it's been a long time for that to get to that point?
I think it could depend. For example, if someone was just pending charges for 10 years, say they were arrested and a fugitive, I mean, I think that you're in a situation where on paper they are still an accused under the Sixth Amendment.
Well, what
So-
document makes them accused?
So in Texas specifically, someone becomes an accused when they're taken before a magistrate under Rothgary.
So
And
is
then
there,
actually,
this is where I think this is the crux of our issue, I think is when does that go away? If she's
If
been
it goes
taken
away.
before a magistrate,
Does
does
it
that
go away?
go away?
Does it go away? If it goes away, when would it do that?
and so our contention is that, yes, that goes away when the charges are dismissed.
Let me ask you this. You would concede that in that circumstance, if we were dealing with a crime that had no statute of limitations, the right would clearly expire when the statute of limitation expired.
I would agree.
This case has no statute of limitations.
That's correct.
Why then, if you can't pinpoint a specific time that it expires, why then in a case with no statute of limitations would it expire?
So specifically, it's circling back to, I know I'm going to sound like a broken record, but the Sixth Amendment, it applies when someone is an accused in a criminal prosecution. And I think Fry touches on this a little bit, although it doesn't use the words explicitly. It doesn't state explicitly someone's no longer an accused when the charges are dismissed. It does suggest that they're no longer in an adversarial position. So Fry is creating that exception where, although charges were dismissed in Fry, that adversarial process, it was never really put on hold. So here our contention is that this dismissal and lapse of time resulted, that terminated her Sixth Amendment right to counsel.
Can I ask you kind of a broad gauge question here, Ben? What is the Sixth Amendment designed to sort of protect compared to, say, the Fifth Amendment? Because like the Fifth Amendment, Supreme Court precedent allows for sort of a reapproachment and after someone has been released and for 2 weeks they've reclimatized or reacclimated or they're no longer under that kind of coercive effect when police question them. Is the Sixth Amendment targeting the same thing? Is the Sixth Amendment targeting some other right? Is it concerned with some other idea?
And I think they're similar in that the Fifth Amendment right to counsel, or the rights suggested with Miranda, those are going to apply to custodial interrogations. So I think that there's overlap and that this is going to apply when there are when someone is formally an accused. But I think that they're also still distinct. I don't know that there's any case, for example, with Miranda that would suggest that the Miranda rights last in perpetuity.
Sure.
And I think,
You're right. There's a specific case that says the Miranda rights, if you've let the person go, your Miranda rights, you have to reassert them, at 2 weeks later. So I agree with you on that. I guess I'm just trying to understand, why is it there could be a rule that limits Miranda, but why wouldn't there be a rule that could limit the Sixth Amendment unless the two things are getting at different ideas? And I want to know what those ideas are, because I can kind of gather that custodial interrogation under the Fifth Amendment is about a coercive environment for the person being questioned, versus the Sixth Amendment seems more about a relationship with the attorney.
And I think some of what the case law suggests is that the Sixth Amendment, the interest there is in protecting someone who's not educated in the law from, I think it suggests the, I don't know, the strength of the state, for lack of a better word, and making sure that that adversarial process is evened out, if you will.
Okay, that's good. Thank you.
Just so we're clear, she wasn't re-Mirandized when they approached her 10 years later, right?
That's exactly right. So she was not re-Mirandized. So for example, I know one of the cases cited in McDonald's brief is Montejo. And I'll just suggest that Montejo is a different factual scenario. So I think it does stand for the proposition that if Lieutenant Sullivan had gone to her house, read her Miranda rights, assuming she had a Sixth Amendment right to counsel to waive, which we're suggesting she doesn't, but assuming that she had that, Montejo suggests that that would have been okay. She could have been read her Miranda rights and then waived them. So I don't think Montejo changes anything just because we're talking about a different factual scenario where we're asserting
Right. In
there's
that
no Sixth
situation,
Amendment right to counsel.
that's part of the confusion I'm having. The Fifth and the Sixth Amendment in Montejo are sort of almost treated the same, but then there's also other case law that sort of says they're getting at different things. What I wanted to ask though, like before you get taken off on another topic though, are you suggesting that there was a waiver in this case? Is that part of the argument? There was a waiver of the Sixth Amendment right, or you're simply saying that it never attached?
So we're suggesting it never attached.
Okay.
And admittedly
I'm sorry,
that,
Or dissolved? or
It
detached?
clearly
Sorry.
attached at the Article 1517 here. Are you really suggesting it didn't attach?
No, that's my bond. That's my
All right,
bond.
I'm sorry.
you're correct. I do apologize for that. So just to kind of quickly circle back to that, we're all in agreement that her Sixth Amendment right to counsel attached originally
Right.
when she was arrested and taken before a magistrate. Our contention is just that that no longer applied 10 years after.
When did it
Well,
stop?
So going back to,
Specifically.
so when the charges were dismissed is our position.
That's
What we would-
that's a technical answer, right?
Yes,
It's a nice, clean, bright line rule.
right.
Then you have the soft, practical answer of, at some point between that day and 10 years later, and we would have to come up with something that would work in future cases to guide trial courts, right?
So what I'll point to is actually language from Perry. So Perry's actually a case out of West Virginia, or maybe it's Sims actually. I think it's case out of West Virginia where it has a very similar factual pattern where the defendant there was arrested for arson. His case was actually dismissed. I believe it was by a magistrate judge after proceeding. 2 years later, they get some additional information. They go back and actually send someone with a wire to go talk to him. And there, the court in West Virginia said that there was no Sixth Amendment right to counsel violation. And so we have a similar factual pattern talking about the same Sixth Amendment right to counsel. And I think the language that they use provides a relatively clean test. And so what they say is, we hold that unless a criminal defendant can show that the government has obtained a dismissal of adversarial judicial criminal proceedings against him or her in order to circumvent his or her constitutional rights, once such criminal proceedings have been dismissed, the right to counsel granted by the Sixth Amendment to the United States Constitution no longer applies, regardless of whether the defendant is represented by counsel. So what they're getting at that I think this court should also follow is that there needs to be some kind of nexus between the dismissal of charges, for example, having a further investigation. So if you dismiss it for further investigation, like in Fry, and then pick that case up, mere months after, I think that is a scenario where someone is still an accused under the Sixth
Doesn't
Amendment.
that advocate strongly against your, I assume, proposed rule of dropping the Sixth Amendment right when the no bill occurs? Because the state could simply get a no bill that removes the Sixth Amendment right to counsel, and their investigators could go and directly question the suspect.
And so I think this gets at a scenario where courts would be looking at whether or not there was actually some kind of intent to circumvent that right. For example, going to a grand jury, getting a no bill, and then immediately
And intent
turning
to
back around and-
circumvent it at what point? At the time of the dismissal or at the time that they approach her for questions?
So I believe that there needs to be some kind of nexus between the dismissal and then
they would have to show that there was some bad intent at the time of the dismissal.
I believe-
under Your scenario.
I believe the case law suggests that. I can see that I'm over time. I would ask to reserve the remainder of my time for my
I can answer
co-counsel.
the question.
Yes.
I have one question. I blew you off course with a poorly phrased question, but I did want to get back to, is the contention for the state here that there was a waiver of the Sixth Amendment right, or that there never was, there wasn't a Sixth Amendment right at the time of the question,
Our contention is that there was not a Sixth Amendment right to counsel at the
later
at the
question?
later question.
Okay.
That's right. Thank you, Your Honors.
Thank you, counsel.
Okay, so may it please the court and opposing counsel, my name is Dean Dyson, and along with co-counsel Stephen Gilmore, we represent the party who prevailed in both the trial court and the Intermediate Court of Appeals
Counsel,
below.
if you could approach the mic, maybe. It'd
Yeah,
help
I'm
a little bit.
Trying to watch my screen as well.
Go ahead.
Maybe this will be better. All right, so we represent the party who won in both the trial court and the Intermediate Appellate Court of Appeals, Ms. Amanda McDonald, the appellee. Counsel notes this case is about the right to counsel, if and when it can attach, if and when it can detach, if and when it may be asserted, and of course, how. And what
Counsel-
events? What
counsel,
events
this is-
do all these things?
This is a purely legal question, though. Like you mentioned that they won in the trial, that you won in the trial court and the Court of Appeals, but we're really dealing with a de novo review here.
Yes, sir.
Okay.
It's a pure question of law
Okay.
that this court is at least equally equipped to handle,
Thank you.
irrespective of what happened below.
The state seemed a little bit foggy on the dismissal process. Are you familiar with what took place in the trial court? Is there a document in the court's file? Usually in Bear County, you have the little boxes that they check and say insufficient evidence or whatever. Is there anything
Right,
like
so
that?
there was no dismissal in this case.
Okay.
Under 3202, the Texas Code of Criminal Procedure, no, let me do this real quick. Specifically, under 3202, lost it, God damn it. I hate wasting my time like this, but it's the CCP is directly on point, and it says that
I mean, we can look it up.
no dismissal may be had without the permission of the presiding judge, without the consent of the presiding judge. So a dismissal is something you have to go to a trial court for after a trial court's jurisdiction has already attached. No trial court jurisdiction attached in this case until May of 2020.
What effect, if any, does the grand juries having returned a no bill, right? What, does that have any legal effect whatsoever?
Well, I think it shows that they
It's not
didn't,
jeopardy, right? Doesn't jeopardy bar going back to ask again? But the way the case got started, before the person went to the magistrate, there had to be a complaint filed by law enforcement officer.
yes, sir.
And I take it that complaint, along with whatever evidence the state had to show to the grand jury, was presented to the grand jury. The grand jury said, nope, you ain't got it. And so, and so then the state decided, well, let's do this again. Because the courts have said they get to do that. So they go back to the second grand jury and they say, here, this officer has filed a complaint.
Not enough.
We've got some evidence. Look at this evidence. And once again, the grand jury says, nope, sorry. So does that have any legal effect? Is that in terms of what we're arguing for, or we're trying to figure out whether there's a dismissal? Does that have,
The only legal effect is it means that they can't proceed to trial
Okay.
without a felony indictment. And that the grand juries apparently were pretty consistent with the fact that whatever was presented to them was not enough to warrant a charging instrument.
More pointedly, is she then not an accused?
Absolutely not. She became an accused when she was taken before a magistrate judge in September. And
Is it your
again,
position then
What
that
year?
that title accused holds indefinitely until she's either acquitted or convicted?
well, the state's ability to prosecute her certainly didn't expire. And I think it would take a huge suspension of disbelief to say that the parties' positions were somehow less solidly adverse to one another in
So your position is
August
that
of
once
2018.
accused, always accused until a verdict.
I would say as long as they can keep going back to grand juries, the right that attached and was asserted in 2007 remains in full force and effect so long as she maintains
That would keep her in
counsel.
potential jeopardy. What makes her an accused?
Uh,
Let me ask you this question. If she had been appointed counsel, couldn't afford counsel, but appointed counsel, and she had asked for a meeting the day before her encounter with a police officer, what would you point to make somebody have to pay that lawyer to visit with her? What would be the basis on which she would say, my appointed counsel should be working for me today? Just the potential that the case was no-billed 8 years ago, and the statute of limitations is open. That's enough to maintain the attorney-client relationship.
Well,
I'm not talking about the potential, abstract potential for somebody going back to the grand jury. What makes him her lawyer that day?
It's a great question. It's just not applicable to this case because, of course, she hired counsel. She wasn't appointed counsel, and she maintained it throughout. So that's
Okay.
sort of the factual complexion
How so?
we're operating on.
How so?
All right, so the right attached in 2.7 in magistration. We have post-attachment assertion by hiring a counsel, and she's maintained it throughout. Further, when
Does the act of hiring counsel assert a Sixth Amendment right?
that's exactly what the case, what this court said. In
The court essentially noted that the person cannot go right to counsel just before a valid right has to.
That's a
right.
Finley case, though, isn't it?
Has right for invocation. Well, in my case with Justice Scalia, made very clear that the Fifth Amendment right, the Sixth Amendment right, both ways the exact same. Granted, has to do with the waiver well, the Fifth Amendment right to capture that arrest and refuse so long as the person does see something like acts of administration, all criminal proceedings associated with the specific offenses charged. So unlike the Fifth Amendment, the Sixth Amendment is offense specific. However, Justice Scalia also noted that interrogation by the police is itself a criminal proceeding. As long as the interrogation is about the same specific charges, which the Sixth Amendment right is already attached, the waiver is required. They can't go in and speak to somebody with an attached Sixth Amendment right about unrelated offenses. They're not about the ones that are charged, but here they're exactly the same. Exactly as. But so the whole view there was that uncounseled waivers can be valid so long as the Miranda warrants are given. And Mr. Montejo, he had both because he had been magistrate and court custody. He was protected by both the Fifth Amendment right and the Sixth Amendment right. What this court did with Johnson was say that the right has to be right. Verification first, signature, temperature, and second. So briefly on the facts.
But isn't this like, I appreciate the side to it, but maybe the reason people didn't cite to the case is because this isn't a premature invocation. This is post-mature invocation. Like, right? This is something that happened way after. We know there was an attachment. How do you get around the fact, though, that she, after hearing all this stuff, I don't want to talk to you, then comes back by herself and says, come back. I want to talk to this guy about this.
Right. A suppression vote can be
Okay.
They never argued. The difference between forfeiture and waiver is that waivers require express conduct or action, and forfeiture happens in future.
So we're not here.
They argue neither forfeiture, and that's why Johnson doesn't apply.
We're only here talking about whether or not this right, whether he's accused of this right is attached on this. At the moment,
I think the more proper way of looking at it is, did some event happen to cause it to become? Because there's no question about whether or not it was passed. There's no question about whether or not there was a surge. The question of what is whether or not she's still enjoyed the Sixth Amendment right 10 years after no bail. The only question presented to this court is, does 10 years and a no bail kill the right? That's the only question that there's up for review. Now they're trying to say, oh, well, we dismissed. No, they didn't. There's certainly no evidence of a dismissal. A dismissal is something you ask for a judge for after its jurisdiction has passed. No jurisdiction has ever passed to a trial court until May of 2020. Okay? At that point, they might have to go to the judge. I would say that their position might be infinitely better if there had been a dismissal, but there was a dismissal Friday, full-fledged one, signed by a judge, and the Sixth Amendment rights still was survive. There was no dismissal. There was a
Do you
rejection.
make any, is there any
There was a
distinction?
rejection.
Is there a distinction to be made? Is there a distinction to be made between the fact that right, it was one who was a prosecutor, a fellow investigator, and they created an investigator versus it's looks like it appears to be these films is that
The court feels a really good answer to that. Knowledge didn't once they find out an actor isn't treated to the other, and they saw no principal difference between the prosecutor going back and being crooked and other state actors going back and being crooked. The Sixth Amendment question here doesn't have to be much. I don't know if I've followed you. But there is also. Yes, sir. Yes, sir. So due process is an ample ground, and quite frankly, probably one that the court should have considered in front. They didn't dismiss the prejudice in that case because counsel was not present there for a phone call. They dismissed the prejudice because the crooked tactics that the investigators used, deeply misleading. The same thing happened in state community life here. Judge Hill was involved with that. Here they told her things like, you're not in any trouble. And there's nothing you can do about all alcohol concentration in your court. There's nothing we can do. If you were drunk when you drove that night, there's nothing we can do about that. Those were the abjectly false news that they fed her to get her to give up the short. But one legal element that they knew they relied on, nobody knew who was behind the wheel of the car. They needed to wield her. And so they specifically said, well, if you give us these types of facts, there'll be no downside. That is the quintessential type positive promise that was treated in Garcia.
Is that part of the ground that you granted?
Well, we don't need to judge because, as you noted, this is purely a question of law, and this question can be affirmed on any ground.
Did the lower court make the decision on that? Is that part of the decision below?
They did not. We raised it in the trial court from their motions. The trial court wrote what findings of fact that he did. And I will also note that they said they should get a pass because we need to show that they had the specific intent to circumvent the Sixth Amendment right. What about all the
and their conduct. Wouldn't we also be able to get into good faith exceptions?
Perhaps if that were the case, but the U.S. Supreme Court, first of all, the case from West Virginia, not binding in Texas. This notion that we have to somehow show specific intent is wrong on the law. The United States Supreme Court has been very clear that I don't have to show specific intent to circumvent the Sixth Amendment in order to establish a Sixth Amendment violation. To establish a Sixth Amendment violation, I need to only show a knowing violation, which is that they knew she had counsel and interviewed her anyway without random.
Where in the record do we find proof that they do this? This is the question I asked just a second ago at a good faith exception. I've got your chicanery and trickery and the investigation. But how would an ordinary police officer understand how long the scope of the attorney-client relationship is after the no bill?
Well, it would have been nice if maybe they consulted somebody with the secretary's office, but Detective
Yeah,
Sullivan.
but they didn't. I mean, the
Right,
question is
and
whether-
now they want to be rewarded for that lack of effort.
Don't you think that 2 no bills would be noticed enough that the case was not being pursued over a 10-year period of time? And apparently the defense attorney wasn't too worried about it because he didn't seek out the dismissal. There's no evidence of that in the record.
Well, I don't know that it's within the burden to seek out.
I know, but you're just talking about the facts and the passage of time and what didn't and didn't happen. So you have the 2 charges that were no billed twice. And why couldn't the police officer have the understanding that, the over a 10-year period of time that the DA's office had not taken any further action?
If I understand the question correctly, at some point she should have been put on notice that I no longer have a Sixth Amendment right because time passed. We're going to evaporate if we want. bright line in that hourglass of time that would have told her that she needed to do something else to alert these officers that, hey.
That's what we're going to decide today. I have a question. I have a question. You said that the West Virginia law is not binding, and that's true. So why do you not think the proposed guideline rule in that case would not be workable for us here in Texas?
It's just wrong on the law. Mainly on, it's very, very clear that I don't need to show specific intent. I just need to show that they knew she had counsel. She told you 3 times that she did. That is very unrealistic to expect somebody in her position when the cops come home to your home 12 years later and start interrogating you, that she's then has some sort of obligation to ask them for counsel. They couldn't have prevented, they couldn't have given her counsel if she asked.
She seemed to know that she didn't have to talk to her, right? And she said, I don't have to talk to you about my lawyer. Was that, what, does that have any, what if her lawyer had been standing there next to her at the time she said to the police, I don't have to talk to you without my lawyer?
Okay. I think what you're trying to say is that she waived the
But
right.
I'll talk to you, not that guy, but I'll talk to you.
So perhaps she
So was
waived,
that
perhaps
a
she,
voluntary?
perhaps she waived the right by that conduct.
I still like it. I have that question.
You know, it's a great argument. I really wish that the state had raised it in the trial court and we had rulings on it and that it was somehow right for our review. But those theories are legally up for debate. Neither is forfeiture, which is what the court found in
But I want to come
Johnson.
back, what about positive comments? Is that part of the decision? Is that what 38?
They didn't, I have no finding. I asked my brief for taking here, so we go back and give up the rulings.
But did you argue that for the future arguments?
Okay. I would have proposed findings of fact that include the law on those points as alternate basis. But as you yourself pointed out,
The only thing I'm getting at is that when I look at the issue, it's specifically targeted. I agree with you. That there's a decent argument out there. No, everything's done. You couldn't go back and do this. I agree with you that seems instinctual to be problematic for the research product in that regard. But I just don't know whether that's something that we get to.
Well, the specific question.
What we have granted, to looking at and what is part of the decision
Well, it is focused on the 60, and the issue granted is actually even more narrow than that. The only thing that was granted here is the passage of time plus the no bill filled around. And there's just absolutely no reason in the world to say yes to that. You know, then you might say, well, what about the dismissal? Well, there wasn't a dismissal, right? There was a rejection, a de facto rejection for further investigation, no different than a crime. And the methods that the cops used here were crooked and felt timely. I don't want to give up. Yes, sir.
I don't read Friday ways. I don't read it. I read it by the extension when the state is engaged in misconduct related to. And that way, there's the issue here of the officer specifically saying on the video, he's deliberately trying to go back to make your caution before you retain. Does that amount to the same type of misconduct that the state was engaged in?
Well, there are different interrogators here. Here we had police, there we had prosecutors. But yeah, I think the essence of the crookedness is very similar. They were in both cases trying to affirmatively lead a defendant that if they gave up the goods, and specifically ones that they needed to show, the one legal element that they needed for an indictment, there would be no doubt. That was a positive response. And if it's countenance, floodgates will open. You know, if they, it's one thing to lie about an evidentiary matter. You know, we got your co-defendant saying in the physical next door. We got your DNA from the scene. No, nothing in that implies that they're not going to use everything that they have. Indeed, to the contrary, they're trying to say, we're going to use everything we got and things that we don't. Whereas here they're saying, you go ahead and go and talk to us about your drunk driving. There's no downside to it. That can't be right. That can't be right. I understand that. We know we're here with our hands. We pray that the courts will. Thank you. Counsel,
morning.
before you start, I would like to ask you a question and kind of make sure I'm understanding this correctly. You've heard the word police officer many times today. But isn't it true that this police officer wasn't just a police officer, he was a seasoned detective?
Yes, he was, I think, a sergeant or lieutenant maybe at the time.
He was the same detective that was on the case 10 years ago.
That is correct.
And it can be inferred that two no bills has really got under his skin, and he's still after 10 years after this person.
I think his testimony is this case haunted him, and I believe his testimony is that he was a traffic detective who rotated out to another department, another division. He came back in, and the case still sat with him, and he wanted to have another crack at it.
And doesn't it seem from his interaction with the defendant in this case that he was indeed adversarial even after 10 years? And when he was speaking to this person, he was being adversarial.
Yes, he was investigating a crime. So Amanda McDonald in this case was in the same position that any suspect would be in when they're being faced by a police officer who's asking a potentially incriminating question. She had statutory and constitutional safeguards as far as her statements goes, and there's no findings to support any adverse ruling on those at this time, but those are still, this is an interlocutory appeal. The defense is still free to pursue those before a jury hears this statement. But I would also note that a police officer cannot make someone an accused. An accused is when someone is in formal legal proceedings. Police officers can make them suspects all day long, but they cannot formally charge anyone. That has to be done before a magistrate.
So you're saying that
That complaint was dismissed, I believe, in May. I believe it's finding number 7. And then Mr. Appelt answered questions, and the judge found Mr. Appelt credible. But Mr. Appelt was asked whether she was on bond. He said no. Did she have any court dates? No. Did she have any accusations pending? He said no. So I think what you can infer from this record, and again, we don't have the actual document. I'm assuming the passage of time, things do get lost. Was that she was charged by complaint at the time of her arrest. She was magistrated. She did have a Sixth Amendment right to counsel. She retained Joseph Appelt to forward that right. And then a year later, there were 2 no bills. I don't know if they were sequential in both cases or one case or the other. I don't know how that worked. And the lawyers who were a part of that process are no longer employed at our office. But from that moment until the time Detective Sullivan or Lieutenant Sullivan reapproached her house, there was a passage of 10 years where she was under no bond conditions, no restraint of her liberty. So I think we can and the judges, he used the term dismissal in finding number 7.
What evidence supported that finding?
So I believe the no bills plus Joseph Appelt's testimony that she was under she was not on bail. She had no court dates and she had no formal accusations.
So when did it detach that right to the council?
I agree with my co-counsel's proposition that as a bright line rule, kind of like Miranda's a bright line rule, it attached at the moment of dismissal. Now, Miranda also has exceptions, and I think that's common in the law.
So really, the passage of time has nothing to do with it.
The passage of time makes it difficult for them. There's 2 things that I think they're going to have a difficult time overcoming the bright line rule. One is the passage of time. Because in Fry, there's a mere weeks or maybe a month, and then the person is immediately reapproached and interrogated about the same matters. Here you have a 10-year passage. The other thing is that this case appears to have been terminated initially. The impetus behind that is a grand jury, an independent body saying you don't have enough evidence. And then the passage of time shows that the prosecution had lost interest in the case. And it was a detective who just felt bad about what had happened, and he wanted to go take a second crack at it.
Did the defendant ever post bond, and was bond ever, did someone ever declare she could be off bond and the bond doesn't count anymore?
I don't know if she posted bond or not. I don't know back in 2007 if she was in custody the entire time. I'm guessing if she had retained counsel, I would imagine she posted bond too. That's just the way things normally work. But in order for her to be an accused, if there's a criminal complaint, there has to be at a minimum a bail or a PR bond that keeps you tied to the court. And without having that, we can infer that there was no longer a criminal complaint.
And one more question, counsel. I've heard from both sides that there were some things that are not in the record that maybe should have been in the record. And I just want to make sure that it's understood, and maybe I'm wrong. Isn't it the state that generally has more control over the record and what might be there than the defense?
I would generally, yes, either the clerk or the DA's office. I do not know. I cannot, because of the passage of time, I cannot speak to what happened to these documents. It would have been nice to have the complaint and the dismissal form in the record in this case. I do believe Mr. Appelt's testimony and the overall circumstances of the case clearly establish, and they support the judge's findings that this matter was dismissed.
Your name is?
Nathan Morey.
I don't think we let you get that part out. Before your light's red, but for the benefit of the law students here today, at what point in their career after they've been counsel to clients are they free to disclose privileged communications from those clients to third parties, the public, or anyone else?
Never.
Okay. Why is there a different rule for purposes of the Sixth Amendment's right to counsel?
So I already said a police officer can't create the right to counsel. Neither can a lawyer. The attorney-client relationship does not create the right to counsel. If it did, then anybody who could afford a lawyer when they're a suspect would have a right to counsel, when the remaining law under our Constitution only gives indigent people a right to counsel when they're in custody or when they've been formally charged. And to say that there is an attorney-client relationship, that in and of itself creates the right to counsel, would be a perverse rule that would divide. And I think Your Honor already touched on that, is if she was indigent and Mr. Appel had not actually been her lawyer.
Well, sometimes I get to play both sides. That's
Yeah.
my job here. Yeah. Okay, well, counsel, thank you very much, unless there's
Thank you.
questions.
I have one very brief question.
All right, we do
Very
have-
brief, I promise. You heard me say I don't read Fry as broadly as the Court of Appeals does. Okay. What I need to know, and what I want you to tell me as briefly as you can, is how do I get past the trial court's finding of fact, which we're supposed to defer to almost entirely, that this detective knew when he went to Appellee's house to interview her that she was represented by counsel? Those are the findings of fact the trial court made. They seem borderline dispositive on what's the central issue for us. So assuming I want to go with the state's position, assuming I don't read Fry as broadly as the defendants, how do I get past the trial court's findings of fact?
Because lawyers do not make a person an accused. A magistrate does. Formal charges do. And again,
So we
this
should
gets,
just disregard those facts.
they're immaterial.
Okay.
Imagine, and I'll be very succinct, imagine if she had just been pulled over in a traffic stop and she said, I got a lawyer and I don't want to talk to you. He represents me in all criminal matters. That would not impede the police officer. I mean, the police officer would have other rules,
No Sixth
Miranda,
Amendment right.
but there would be no Sixth Amendment right.
What
And I
if you
think
pulled her over for something that had been dismissed the day before?
that would present a very interesting question. I do, in all seriousness,
So
I
how much
think-
time do we have now?
if you want to give Mr. Dyson more time, I do think there's bookend cases. This is a clear bookend because of the 10 years. You have Fry, which is a mere matter of weeks. Judge Neil Keel, sorry, I apologize. I do think there's always going to be the cases that are in the gray area in the middle. This court's always going to struggle with them, and judges are always going to struggle with them. This case does not present the gray area because of the 10 years.
Okay, we're a
think-
little over on time.
thank you.
Thank you very much for your arguments. We'll take this matter under submission and we'll stand briefly in recess. All right. Thanks, sir. Indeed. Yeah. That's been a big one. Thanks, sir.
Well, you're the Rockwell, that's the smallest. You got a lot of people. You don't get calls all the time? I got a call a while ago.
Yes.
Just hold on to guys' voice I feel like the police is there when you come this way.
Good morning. If you are joining us for this is your first case, we're asking everyone to please remain seated throughout the argument. And a friendly reminder that the court does not allow the use of electronic devices during argument, and they will be in shortly.
guys.
Please be seated. I will now call our second case on the docket this morning, PD 086624, State of Texas versus Saul Lee Suarez. We'll hear first from counsel from the state. If you could please again identify yourself as you approach the microphone, I'd appreciate it.
Yes, sir. My name, excuse me, my name is Doug Howell. I'm an assistant district attorney in Brazos County, Texas. We are here today on a state's appeal. The trial court granted a motion to suppress in a murder case, thereby suppressing the evidence that was located in a bedroom of an apartment. The basic facts leading up to this motion to suppress: we had a murder in 2017 in a park in Bryan. Gunshots back and forth. The brother of Anthony Lopez, who was found in this apartment bedroom, called his brother and said, "I've been shot." That was the first kind of lead the Bryan PD had all day. They got the Anthony Lopez's phone, they pinged it, and they traced the ping to this apartment complex. They eventually came to the apartment run, or the mother who signed the lease of this apartment, Sylvia Sanchez. She was there with the defendant, or appellee, Saul Suarez, her son, a niece who had been babysitting two babies all day, her mother, who was in a wheelchair, and then a nephew. And so the police arrived. They found Anthony Lopez in the back bedroom, brought him out, found that he had been shot, took him to the hospital. And then our lead detective, who had been working various other aspects of the investigation, show up at the apartment and takes over the scene. He is initially asking questions of the mother, and asking her, when did this boy, and that's how she described Anthony Lopez, as this little boy, when did he come in? How did he get in there? And then eventually Detective Davis explains to her, look, there's been a murder. To which she says, I know, because I heard about it. I know the mother. I kind of know the person that was killed, not directly, but I knew it happened. And so we've got Detective Davis then realizing that this potential murder suspect may have brought the murder weapon back to the apartment. And he is concerned that there is a murder weapon in this apartment. And so he goes to the mother, who he is believing is the matriarch of a niece, nephew, son, who is a friend with a little boy, and a mother who is wheelchair bound. And he says, look, we need to search this apartment to find this murder weapon. Are you willing to consent to that? And she initially says yes. Now, we have to remember, before this happened, our SWAT team, or what we call our DDT team, had already entered the apartment to find this suspect, and they brought him out. So she had already consented to that to happen. She also consented to Detective Johnson do another protective sweep, because they were still concerned that there may have been people under the beds or guns out in wherever. They didn't know where anything was. And so That is what Detective Davis had to work with initially. He knew that the murder suspect was in the back bedroom. He knew a possible murder weapon was in there. He knew that the mother had already agreed to allow one protective sweep, thereby showing Detective Davis that she was asserting authority over the entire premises, not just the living room.
What significance, if any, should we give to the fact that there was a lock on the bedroom door and a sliding glass door, I think, that led outside from that bedroom?
Thank
Because
you.
those are, I mean, they seem important.
They are important, but this is what, on apparent authority, we are supposed to stay with an objective standard of, we're not to consider what was the intent of the officer, what was the intent of the person giving
Those seem like
consent.
objective facts, though.
They're objective facts that were given during their testimony, and I,
But the house had already been swept, including the room that had the lock on the door. So even to the extent that the lock implied some superior right of possession of the son, the mother had already consented to a sweep of that room. The door had already either been unlocked or was in a state of unlocked.
That's correct. And so, and again, looking at, we've provided you with the video. I mean, it's very clear that the mom, in a sense, is driving the boat on this back and
Sure.
forth.
Yeah, I think that one of the things that Judge Erie is kind of getting at, though, there's some objective facts in the record that sort of question, that might make it ambiguous as to whether or not the mother has the authority to search or grant authority to search in it. So what facts, how much do you need? Maybe the better question is to ask, whose burden is it to ascertain sufficient facts to let you know so that we can ascertain whether there was apparent authority? Whose burden is that? Is that the defendant? Is that the law enforcement? Is that from a hearing? How do we know when it's an ambiguous situation and we have to say, well, the officer has to do more?
Well, and again, of course, that's the main issue in this case.
Well, do you think it was an ambiguous situation?
No, ma'am, I do not.
And why not?
Yeah, that's a fact. Yeah.
Okay. First off, the 10th Court of Appeals, when deciding ambiguous situation or circumstance, said that there was a multi-generational dynamic in the house. And that's what they laid their opinion on, was that we had grandmother, mother, a son that possibly was an adult, a niece that was possibly an adult, and then a nephew. So 10th Court is saying that the ambiguous situation came from this family unit with different levels of ages. Not, and again, I think if you look at Detective Davis when he is talking to Sylvia Sanchez and asking for consent, and he testified to this, maybe another objective fact, maybe an intent fact. He said, I am used to dealing with roommates. And of course, Texas A&M is Bryan College Station. He probably is used to dealing with that. But that's not the scenario that he is dealing with here. He is dealing with a family unit where the mother is doing all the talking and giving consent to multiple officers.
But just to make sure that we're clear on the actual facts as far as that room, didn't the mother at one time tell the officers that she never goes in there?
She said that,
Okay.
correct. During,
Okay.
she was brought in and she did
Right.
say that.
And then I think the other fact is that the lock between this room and the rest of the apartment was on this, was on the inside of that room, correct? It wasn't on the outside.
That's
It couldn't be opened from inside the rest of the apartment. And
Is there
then
any
I
evidence
assumed
the
the
record-
other lock on the sliding glass door, you couldn't just walk in there without
And that-
unlocking that.
As to the sliding glass door, I apologize, I don't know the answer to that.
Okay.
Yes,
Is
sir.
there any evidence in the record that that door was locked?
No, sir. No, sir. Not at the time of the entry, no, sir. So back to Judge Newell's question about this ambiguous circumstance or situation. I go back to what Waco hung their head on, and that is they relied on the multi-generational family.
Right.
And we have a mother-son relationship here. Yes, Detective Davis did know that there was a son. That was his bedroom. But he was also friends with a little boy who possibly had committed murder, and they were trying to get hold of a murder weapon. And I believe that Detective Davis was reasonable, that these were not ambiguous circumstances. He has told her up front what we're trying to find. She has given 2 to 3 consents, and she's doing all the talking on the video. So I don't believe it's an ambiguous situation.
You know, it's that sometimes you see in the case law, the courts are more lenient with officers when they see a situation in which there's a real danger, you know, like there's a weapon that hasn't been found yet, for example. You know, and I wonder if we take this to just think about it in another context. What if there was a mountain lion that the police suspected was in that room? You know, would the mom could she have given consent to go in and get the mountain lion at that point? Or do you think that the defendant would have said, oh no, she can't go in my room to, you know, get the mountain lion out of there?
Would you need to answer the consent question in that situation, or would you just be
That would be
relying on exigent
emergency.
circumstances? Yeah, emergency.
If they know
I guess
it's
the
a
gun's not going to fire itself, right? Is that
I agree. But they don't know where it is.
And there may be other children that could have access
Well,
to the
you made that
room.
argument in your brief. There's kids present. He's worried about the safety of the kids.
Correct.
I don't know where that
But
puts
if
us.
that's like searching for a gun, seems like that's an emergency exception or
Well,
exigent circumstance.
in Texas, that's a lot of emergencies. Right?
Mhm, mhm.
And what,
I'll ask this of Mr. Phelps as well, but I'm wondering, is this case more like Illinois v. Rodriguez, where you got 2 roommates? Or is it more like Fernandez v. California, where you've got one co-occupant who's not even there to say anything at the moment that the police are asking to go in?
Well, obviously, at the time, Detective Davis asked the mother for consent. Again, he asked her for consent once, and then before he had her sign the consent sheet, he made sure, you're the adult here, aren't you? So I want to say this. I think our detective asked that one last question to make sure there were no, he has been presented with a multi-generational family, but he is still asking the right question. Are you the person I should be dealing with? Are you the actual authority in
Isn't
this
that further
apartment?
inquiry under Rodriguez
I believe it is.
on its face?
I think that's what he did. He made that one additional inquiry that he needed to make.
and isn't it true that the defendant was actually in the front yard in handcuffs and the officer could have just walked out there and asked him for
He
consent?
could. He did not know, I believe. No, I think he did know that he was outside on the capious warrant.
Yeah.
But again, the facts that he was presented with was Anthony Lopez was a little boy. He had not seen Anthony Lopez. He known that Anthony Lopez had been taken out of the apartment and taken to the hospital. But Saul Suarez was his friends with this guy. That's what he was presented with.
Is there any issue in this case regarding sort of the applicable legal standards? Are we simply looking at whether or not those legal standards were properly applied?
I think it's whether they were properly applied.
Thank you.
Yes, sir.
So the trial court should the trial court base its conclusion about what he thinks the officer reasonably believed at the time of the search on what he heard about what the mother did at the time, or should he be more persuaded by what she said when she testified later on and seemed to have a whole different perspective?
And again, I believe that parent authority is an objective review.
Okay.
And I know that we've made a distinction between objective facts and intentional facts. But it's my argument that the video should control, because you are actually seeing how the consent went down.
Control over the trial court's findings of fact? Are you suggesting we should submit our findings of fact based on the video over the trial court's findings of fact because they're based on the video?
Well, the trial court's findings of fact, I think, include or supported by the intentional testimony from the detective that I don't know should have been. For example, I believe one of the conclusions was that the detective took the mom's consent, or that he had authority over the entire premises at face value. Well, that, in my opinion, face value is what the officer is intending when he is trying to reasonably decide if this person has authority over the premises. And therefore, that fact or that conclusion in the trial court's findings of fact conclusion law should be stricken.
But the officer literally testified. She
That-
took her assertion at face value.
Yes.
Those were his literal words.
But that is supported after the fact. That is not what's happening on the video.
Are we really just talking about apparent authority? Are we talking about actual authority? Or is it enough in your mind to just say there was apparent authority?
We're here on apparent authority.
Okay.
I'm down to 7 seconds. Thank you.
Unless there's further questions. Thank you. Have some time for rebuttal, counsel.
May it please the court? Excuse me. May it please the court? Mr. Howell? My name is Shane Phelps. I represent Saul Lee Suarez here, and I represented him by appointment in the trial court. This case comes out of Brazos County. I have fairly significant divergence of opinion about the facts of this case than the state does. But what I do want to address is, I think, the questions that the judges have been asking, which is, it appears that the position of the state is that the only thing that should control here is the video. That you, as the Court of Criminal Appeals, put aside what the Court of Appeals did, but you, as the Court of Criminal Appeals, should ignore the Court of Appeals opinion, should ignore what the judge did, should ignore the trial court's findings of fact that are supported by the record, and just decide this based on the video.
When they arrested him, did they have an arrest warrant?
No. You're talking about my client?
Yes.
He was arrested on a capious profile for a Class C misdemeanor in the middle of a murder investigation.
But you're not alleging that that's improper.
Are you asking my opinion?
No, I'm asking, under the law, they're entitled to do that.
They are not entitled to do it if the purpose was to put him outside so that
Pretext
when
stops,
Detective
pretext
Davis
arrest,
asks for consent, he doesn't have to worry about looking, it's kind of a Georgia versus Randolph situation, which is not present here.
How is this different than Fernandez v. California?
In what respect, Judge?
In the sense that that's the one with the co-occupant who's been taken into custody at that point, and the wife, I think, is the one remaining at the door, and the Supreme Court allows her to give consent for the officers to come in.
I don't recall in that case whether there was an objection. I know that was the point of Georgia versus Randolph.
Right.
Here, he was outside. I think the issue, and the state has tried to confine the analysis of, excuse me, the analysis of what Detective Davis knew to just what he knew in his head, irrespective of everything else that was going on, including the fact that my client, Saul Suarez, was just outside the apartment available to him to ask for consent. And that is really important because ultimately there is no question from the state of this record, from the videos, that the focus of this search was always going to be, as Detective Davis was questioning Sylvia Suarez, the back bedroom. Saul
But the
Suarez's
back
bedroom.
was where the guy bleeding from a bullet wound was found.
Absolutely.
It's reasonable for the police officer to have focused there.
Oh, I absolutely. Except, and the Court of Appeals points this out, Detective Davis spent a great deal of his time, about 5 or 6 minutes, talking to Sylvia Suarez about Anthony Lopez. And maybe he could, we don't know where he is in this apartment, even though Angel absolutely unequivocally told him, no.
Just to
I've
clarify,
been
you mean
here.
where he was in the apartment, because at this point, during this conversation, Lopez was in the ambulance on the way to hospital.
Yes, sir. But I don't think there's any question at all that Anthony Lopez was ever anywhere other than in Saul Suarez's bedroom.
The
He
officers
came-
have no way to know that.
I'm sorry?
The officers have no way to know that. When they came in, they swept the whole house because they were dealing with a gunshot and a murder.
I believe that the evidence shows that when the officers came in, the SWAT team, they went straight to that bedroom. And if you watch the video, there's pounding on the door. We know you're in there. And ultimately, the door opens up.
Okay. but
Counsel.
I'm sorry, go ahead.
I was just gonna ask, like, because this was asked of the state before.
Yes, sir.
Do you think that the question of whether there was an apparent authority was based upon an ambiguous situation? Or do you think that would require the officer to ask more? Or do you think it was unambiguous and they just didn't have authority at all?
Well, I think that well, first of all, there is no actual authority before this court.
Right.
The state abandoned that when they did their petition for discretionary review and their brief on the merits. It is clear to me, at least, that this was an ambiguous situation that gave rise to the obligation on the part of Detective Davis to inquire further.
Why?
They acknowledged, the detective did, and it's in the findings of fact, which I think the court should consider because I think the court must consider the findings of fact. This was a chaotic scene. There were at least 10 officers on the scene. He was talking with Sylvia Suarez, but Sylvia Suarez was not doing all the talking. You watch the video. That's just not what's happening. It is 4 or 5 minutes of him saying, we got to look around the apartment for a gun, even though the apartment was completely secure, a protective sweep had been done. Then you have, he asked her the question, ultimately, after he had already obtained consent. The Court of Appeals caught that. I missed it
But before she signed the form, right?
before she signed the
That's
form. So
further inquiry.
he was formalizing it with their form that they used at the Bryan Police Department. And that's when he said, I am assuming, and I think that's incredibly problematic. I am assuming this is your, and I'll just read it from the state's brief. You're the adult here. This is your home.
Tell me the 3 circumstances that you think he knew about at that moment when he asked for consent that made it illegitimate for him to think that she had authority. What 3 things?
But we're in
Did
a
he
two,
know right then?
we're in a small 2-bedroom apartment. He knew that. There are at least 5 people living there. He knew that. He knew that the focus of this search, that Anthony Lopez, who was not a little boy, he was 16, Anthony Lopez was found in the back bedroom by the SWAT team. He knew that. He knew right behind when he asked, you're the adult. She doesn't understand the significance of that. He does. He's the experienced detective with 16 years in the Criminal Investigation Division. She doesn't understand this. He's asking the questions. He tells her, I assume. Right behind her is an elderly woman, an adult, in a wheelchair in the living room.
Mhm.
Sylvia Suarez sleeps in the living room. There is at
Did
least
he know
another.
that? Did he know that?
I don't know if he knew that part or not. Clearly, it was developed at the hearing on the motion to
Right.
suppress.
Can
But
we
I think that speaks
consider-
to actual
All right,
authority.
so are we able to consider those things that were developed at the hearing that were not obvious or apparent to him at the moment that he got consent?
Yes, ma'am, I think you are able to consider the findings of fact that Judge Hilburn signed. However, I do think that the inquiry is what was going on at that apartment at the time he asked for consent.
Right.
And again, you have a chaotic scene, which I think speaks volumes about ambiguity.
What was chaotic about it?
The detective characterized it as a free-for-all. He said that to me when I asked him those questions. There were 10 officers there. There was a lieutenant, a sergeant, another detective, him, and officers all over outside.
Right. So, but.
He didn't
looking
even
at
know
the-
who was
the
in
video-
charge.
The video didn't look chaotic. It doesn't look like chaos.
Oh.
He's in a living room with several people. He's talking, they're giving him information. He's talking to her. It was not loud or out of control. I mean, what do you mean by chaotic? Just because there were a lot of people?
I think this is a woman who just gets home from work and is descended upon by a SWAT team. And the idea that she kept giving consent to a situation where they're looking for a potential murderer in that bedroom, I think is misdirection.
But isn't the only question here what an officer in that situation would have reasonably understood, or whether he would have expected himself to be under duty to further investigate? The fact that there's so few rooms and so many people there, doesn't that trigger in favor of the idea that the adult would have apparent authority? I mean, I'm not sure what the square footage would be, but your argument would be like a third of the living space was walled off to the only apparent adult that this police officer encountered, right? Other than the grandmother.
Yes, sir. I would respectfully disagree. I do not think it speaks to that. I think, and again, if you watch the video, if you listen to her testimony, if you listen to the detective's testimony or read it, that it was clear that there were other adults in the house. It was clear. She even told the officer, I don't get to go back there. And Mr. Howell conceded that.
At the hearing, did she say that at the scene?
I think that's what I heard Mr. Howell say, but I could be mistaken. But that's what I
How
think.
many
I heard.
beds were in Saul
But-
Suarez's bedroom?
Sir,
How many beds were in Saul Suarez's bedroom?
as far as I know, Judge, just one. So the way that it was, Sylvia Suarez slept in the living room with, I presume, her mother. Angel, who is also turns out to be an adult. The niece slept in the one bedroom as you go down the hallway to the left, and then there's Saul's bedroom in the back with the back entrance.
But that's 4 people. Where's the 5th person?
Let's see, Jeremiah, who also, I think, slept in the living room.
Wasn't your client an adult at the time?
He was absolutely an adult, and they knew that he was an adult.
Okay, do you know if this officer knew that he was an adult when he killed?
I believe he did.
Okay.
Now, I think at the time, during his testimony at the motion for this motion to suppress, he denied that. But I also think this speaks to the word available, that everything was available to this officer. Candido Amaya was standing right next to him, the other detective, when he asked, "You're the adult?"
Yeah.
And Detective Amaya did not say word one about the fact that I've already asked this kid, Saul Suarez, and he's 18. And right behind Sylvia Suarez is another adult. So I think those circumstances led to an ambiguity that required the officer to, just one more question.
I want to ask
One
you a
more
question
question.
about that.
Yes, sir.
Right there. Your brief on page 18 says, given all the information available known to Detective Davis at the time he requested consent, the circumstances were ambiguous. Then you say, all that it would have taken to gain valid consent was for Detective Davis to have taken a few seconds to ask 1 or 2 follow-up questions of Sylvia Sanchez.
Yes, sir.
If asking additional questions of Sanchez, and you follow to say that he did not, renders his belief in actual authority rejectable and reasonable. But if 1 or 2 more questions would have established valid consent,
Yes, sir.
would have established she had actual authority, right? Then when we go back to Rodriguez, which actually says the standard we look at as with the facts available to the officer at the moment or demand reasonable caution in the belief that the consented party had authority over the premises. That's limited. But it quotes Rodriguez, and this is the key line out of Rodriguez. If not, entry without further inquiry, which we have here, is unlawful unless actual authority exists. Your brief says a couple of more questions would have established this woman had actual authority.
No, it did not. I don't believe so, Judge. And
It
if I
says
did, it
all
was,
it would have taken to gain valid consent was for the Detective Davis to have taken a few seconds to ask 1 or 2 follow-up questions
yes.
of
And
Sanchez.
and the one question of Sylvia Sanchez would have been, do you have access to Saul Suarez's bedroom?
Then
That
your
question-
argument would be 1 or 2 questions would have established invalid, that she didn't have the authority. But your argument here is 1 or 2 questions would have established, 1 or 2 follow-up questions would have taken a few seconds to ask 1 or 2 follow-up questions. All it would have taken to gain valid consent. Those
Yes,
are
sir.
your words.
So
is
he
for
asked,
Detective Davis to have taken a few seconds to ask 1 or 2 follow-up questions.
if he had asked, do you have access to the back bedroom? And if she had said no,
That would
no
be
actual
valid
authority, no apparent authority, you walk outside and you ask Saul Suarez if you can have consent. I think the concern was that if I walk outside and I ask him in consent, he's already in custody, probably have to Mirandize him, he's going to say no.
Isn't that
And they
like a
have to get a
land
warrant.
title search?
Sir?
Isn't that like a land title search? I mean, what you're looking for is proof of actual authority. If that inquiry obligation is as broad as you say it is, where does a parent authority exist?
Well, and I guess I'm not sure I understand the question.
Does he have
If,
to see the
if,
lease?
if he asks the question, do
To
you
get-
have access,
to-
then
to
she has
exhaust the-
actual
to
authority and the
exhaust
question is. over.
question of
Sir?
To exhaust the question of actual authority, where would there be any room in the law for a parent authority to exist?
If he had asked the question, do you have access to the back bedroom, then it would have dispelled
Yeah,
the
and the
idea that
answer
there's
you
actual
think would
authority.
have been no at the time.
Under
Then
that
he goes out and
circumstance,
asks Saul, and Saul says no. There's never an opportunity in that scope of duty of inquiry to have a parent authority exist, is there?
under that hypothetical, yes, there is no
She
apparent
consented
authority
to the
because if she
security sweep in
tells
the
him she
bedroom.
does not have
But
actual
if the
authority.
scope of the duty of inquiry based on potential ambiguity, which right now he's got a woman saying, I'm the adult here and she's consenting, is that he has to keep asking, what's the basis for your claim of authority? Why are you signing this form? Do I have to go down to the owner of the apartment complex and check the form, see who's a listed tenant?
No, but I think it is important to remember that she didn't assert, this is my apartment. She did not assert, I'm in control. She was not consenting to anything. She simply answered yes to his assumptive question
What's wrong with that
after she had
question?
given.
I don't understand why you keep complaining about the question. He's saying, I'm assuming that implies a question.
Yes, ma'am.
Are you the adult here? Why is that question not sufficient? He's doing his job. He's asking this question. Do you, can you consent, basically, is what he's asking her.
Well,
He's not concluding. He says, I'm assuming, are you the adult here in the house?
and she is not the adult in the house. There is another adult right behind her. Saul Suarez is an adult.
But she
Angel
says,
is an
yes,
adult.
she is. He asked the question, she says, yes, she is.
All she says is yes to that
flip side
assumptive
of
question.
this-
The problem with the question.
Isn't every question an assumptive question, though?
Not when
I
you
mean-
use the word I'm assuming. I mean, the state of the law about apparent authority and about actual authority is that they shouldn't assume. They should not take these
Yeah, but
these
okay,
assertions
so
at
they
face
got- You still
value.
got the answer, and the answer is yes. Doesn't have to cut her in half and count her rings to see if she's the adult, right?
No, I appreciate that, but when there's an adult right behind her and we know that Saul Suarez is an adult.
But the flip side of this whole idea about how big the inquiry has to be is if we don't have some inquiry at all, then the police officer is not incentivized to actually ask more questions to ascertain whether there's real apparent authority. He can just say, do I have consent? The person says yes, and that's it. And he doesn't have to engage in any inquiry. And that leaves open the possibility that this person is consented and it's not valid consent. And it's not apparent that they have authority. They have no facts to base that on. But the officer has no incentive to actually inquire further if they can just simply say, I got consent. This person says they have the consent. They say, this person says they have the authority. That's it.
In every other case that I looked at that talked about apparent authority, there was a circumstance in which they made, not answering an assumption or
Right.
assumptive question, but they made a representation. This is I think it was Mimi was her name. This is my apartment.
That's what the
Here's my
consent
bedroom.
search says here. The written document says my apartment. Those words are literally black letter in the written document she signed to consent to this search.
But that's after she's granted consent. She's just signing a piece of paper. After he's already asked for consent,
So your
she
position
says
is
yes
signing
with
the
no
consent form Is
information.
not granting consent?
Sir?
Your position is signing the consent form is not granting consent?
I think
That's
the
what it's
signing
for.
the consent form was formalizing the consent that he had already asked for and allegedly received.
But the assertion in the form still says that it's her apartment. That's a fact that you can look to say whether there's apparent authority.
But-
Her representation or agreement that this is her apartment.
But when he asked for consent, he didn't ask that question.
Yeah.
It just happened to be on the piece of
Right,
paper that
like
she
saying
signed.
this
He
is
didn't
my
read it to her.
Right. Saying
So-
this is my home isn't the same thing as saying, yes, this is my home and that I have control over that apartment. Like I could live in an apartment and that would be my home, but other people could live in the apartment.
It was everybody's home.
Right. It's
So I mean, the
everybody's
problem with the question is, number one, you're the adult. She's not just the adult. There are other adults, including my client, who is 18 years old with a reasonable expectation of privacy in his bedroom that nobody else could go into without his permission. The other part of that is you're the homeowner. Well, property law doesn't control. The question is an imperfect question. It is an assumption after he's gotten his consent, he thinks. And with his experience, which I think matters, you've got a detective who said, I've done this before, and he acknowledged the importance of getting proper consent in a murder investigation. Ultimately, and we've heard it, I think, time and time and time again in your rulings, as well as the Supreme Court of the United States rulings, get a warrant.
Okay, but counsel, I got to go back to this because I've got to get my brain through this. We're talking about whether this officer had reasonable belief that he could search, okay? She signed a document, verbatim says, I, Sylvia Sanchez, having been requested by Detective Davis of the Byron Police Department to permit him, her, and his fellow officers to search my apartment located at 1824 Wild Oak, and having been informed by him that I do not have to consent in such search and that I have the right to refuse consent to such search, and understanding my rights, I freely and voluntarily consent to such search. She dated it. She signed it. How is it unreasonable for him to rely on that?
Because it's after the fact. He
But
has
he's
talked to her
under the
for 4 or
statute,
5
under the law, under Rodriguez, if there's ambiguity. I'm not
Yes.
saying there is, but if there's ambiguity.
There is.
The duty is to make further inquiry. The literal language is, if not, entry without further inquiry is unlawful unless actual authority exists. But entry without further inquiry, he made further inquiry. He asked her if she was the lady of the house. He asked her, that's further inquiry. And having made that further inquiry, just like Judge Newell said, having gone the extra step, and for me, and I'd like you to address this in a minute,
Yes, sir.
I'm a little confused by why he shows up after the sweep is done.
Yes, sir.
He knows she has consented for the police to do the sweep, including this room. Why can't he rely on that consent? This woman maintained she had the authority to grant consent. She granted the police consent. They did the search. She didn't object. They're still here. He goes beyond and asks again, and then he goes beyond and does further inquiry. Then he has her sign a document, not an affidavit,
Yes, sir.
expressly asserting it's her apartment, expressly asserting she gives free and involuntary consent. Why is it unreasonable for him to rely on that?
Well, first of all, I would like to, I think, clear this up. She did not consent to a protective sweep. People do not consent when SWAT descends on your house in an emergency situation to find a potential murderer in the back bedroom. That's where they knew he was. She did not then consent to another protective sweep. Police officers have a right to do that when they are in pursuit
your
of a murderer. So she
Position is
didn't
the initial
consent. That
entry was
consent-
exigent circumstances?
Sir?
Your position is the initial entry was exigent circumstances?
Absolutely.
without consent.
Absolutely. I mean, it's an emergency circumstance. You got SWAT that is descending on this apartment. They go straight to the bedroom. They pull the alleged murderer out of the bedroom and take him to the hospital because he's been shot. Then they do a protective sweep. In every case I've ever handled where a protective sweep has been involved, they don't stop and say, hey, is it okay if we look around for another murderer or if we look around for a gun? They don't do that. They do a protective sweep to protect the residents and to protect themselves and to prevent the destruction of evidence. They have a right to do that. There's no consent issue there.
And
The
what,
consent here was the question he asked at the time he asked it was, would you give consent after talking about Anthony Lopez? Then he says, as he's getting her to sign the form, which I think if you look at the video, I don't think she even looked at. That's not the information that is important, is the information that was available to this officer at the time he asked that question, not when he's signing the form.
and at what point in time did the officer learn that this room we're talking about was the son's room and it was usually locked from the inside and that she never goes in there? Was that before she signed the form?
She told, with respect to the first part of that, she told Detective Davis, my son's bedroom has a sliding glass door entrance to the outside. I'm paraphrasing, but she expressly told him that. So he knew that it was the bedroom that the defendant had, or Mr. Suarez had. With respect to the other questions, I'm unsure of whether that was at the scene or whether that was at the hearing, honestly.
So you're not for sure if she knew, or if the officer knew that the son kept his door locked from the other side and
I don't
that
think
she
he knew
never
that at the
goes in
time.
there.
But if you watch the video, when the officers, the SWAT team descends, they start pounding on the door. The door is closed. What we know from her testimony is that when he was in his room, the door was always locked. I think you can infer reasonably, which I think the court is entitled to do, that when the police and pounding on the door, it was locked. They unlocked it. They opened up the door in response to the pounding on the door. Because we know that she says when he's in his room, it's always locked.
Counsel, I want to thank you for a
Yes,
very
sir.
fine argument, and I suspect a very fine argument at trial court as well. We're a little bit over on time.
I apologize for that,
No, no,
Judge.
not-
If it was your fault, I'm
It
sorry.
is my fault. Well done, sir. Thank you. Rebuttal.
Yes, Your Honor. I disagree with Mr. Phelps that this court or the Court of Appeals should have been considering intentional testimony taken during the suppression hearing to shore up what Sylvia Sanchez's intent was while everything was
Well, then
going.
what's the point of the hearing?
The point of the hearing at that point was to determine either actual authority or apparent authority. But under apparent authority, we have an objective reasonable standard. And again, whether the facts available to the officers at the moment, consent was requested from the mother, would permit a person of reasonable caution to believe whether the mother had authority over the premises. So the video shows us what the facts were and what the back and forth was between the detective and the mother. We have a motion to suppress hearing where now the mother is supplying, well, that door is locked. I never went back there. All this additional stuff that Detective Davis did not know at the time he was trying to obtain consent and seeing the parameters of this multi-generational family.
By the time he obtained that consent from the mom, I presume the law enforcement had control over that whole environment.
That's correct.
Nobody was going in or out without their say-so. And I'm wondering,
well,
why not go get a warrant at that point? I mean, you can get one for a blood test result in, an hour's time. I don't know how it works in Brazos County, but I assume that, you've got some on-call magistrates that you can go get a warrant from.
I think if you look at Detective Davis's explanations to Sylvia Sanchez before she signed the consent page, he explained to her that he could go get a search warrant. And his explanation was, it's going to take a lot longer if we have to go get a search warrant. We don't want to tear up your apartment. Matter of fact, after she signed the form, he was, if you guys want to follow me or follow my detectives as we go search, you're welcome to follow us. What he was trying to tell her was, I can go.
So
I
it's a
can go
matter
get
of convenience then for the owner of the
for the
apartment?
owner.
or-
Do I keep these guys here for another 2 hours or so while we get the warrant and we do the search? Or I can sign this document because I want this murder weapon out of my apartment. She says, I don't want to have anything to do with this because she knows that the murder suspect is potentially in her home and that the murder weapon is potentially in her home. And the officers are saying, we need to go find this.
Did anyone at the residence ever ask the officers to leave? Anyone?
No. Any other questions?
Did this officer know that Mr. Suarez was in the front yard? For sure.
Not until after, I could be wrong. I think he didn't know until after the consent form had been signed.
But you're not sure at this point?
I don't remember
I
exactly.
understand.
I think our briefs will reflect it.
And what he was telling, the mother, the things you just mentioned, about, it sounds kind of like we can do this the hard way, the easy way. You either sign the form or
Well-
we're going to tear your house apart.
Let me say this. That's the great thing about this video. You can see from the video that all of the detectives inside that apartment were very respectful of Miss Sanchez and everybody there. They were very polite. Again, they said, we don't want to tear up your house. You can follow us around while we do the search. So there wasn't, based on the demeanor in the video, I think it's clear this was not a threatening stance. It was just more of an information search warrant which will take a little bit longer, or you can sign a consent to search
But
form
what-
if
what's
you
the-
are
But what's
the
the
adult.
purpose of them saying we don't want to tear up your house if it's not to coerce her to sign the form?
Because he had said previous to that, we don't know where this gun could be. There was 2 back bedrooms and there was rooms in the front, and he was just explaining to him, we don't want to go into every little nook and cranny. We are looking for a gun, a shotgun, bullets, and a cell phone. And so I think what he was trying to do is let her know we're not going to be throwing mattresses or pulling out drawers and just go willy-nilly on everything. We're going to limit our search to look for those particular items. And I think that's apparent from the video.
Thank you.
One last thing before you go. Your brief is pretty firm on the idea that videotapes play a special role in appellate review here, but our district courts are our primary fact finders in this system. Is it fair to them to just supplant them whenever we have a videotape available for us to look at?
I think the key here is that I would say not under an actual authority argument, because I think a trial court has the right to consider testimony to determine actual authority, but not under apparent authority because of the objective reasonable standard of review.
Thank you both. Hope you'll stay. Appreciate your arguments. We will now take this case under submission and we will stand in recess.
All right. Oyez, oyez, oyez. Court of Criminal Appeals now stands recess, subject to the call of the presiding judge.
Thank you. You too? Yes, sir.
The court will be in recess for about 5 minutes and then they'll come back for a Q&A session. So, think of some good questions.
Well,